First of all, there's a question on ownership of lectures, which has come in via Twitter. Presumably, institution owns the video of the lecture. What happens to archived material? But hopefully, as I mentioned at the end of that, there's a number of rights. And again, it's about ownership of the rights in the lecture rather than in the actual digital file itself. The right to reuse copyright material or material protected by any intellectual property is down to those rights. And it's important to get those rights sorted out before you start. In the normal situation, the academic is doing the lecture in the course of their employment. That means the content of the lecture belongs to the employer, except for third-party material. If I'm showing someone else's stuff, well, first of all, I should clear the right to do that. I should ask permission, unless it's for reviewing criticism, in which case I have the fair dealing defence that I can use, but that must be fair, and it must be truly restricted to review and criticism. The extent to which that can be pushed is a difficult question, and it's a matter of risk appetite, and that's for you to decide in many ways. You also have the rights in the recording that's made, and that will belong to the person who organises the recording. There is an argument to say if it's the institution organising the recording to be made, then it owns the recording. Normally, the rights are just to make sure you get the person who's making the recording to sign something to say that the rights get handed over. What you want to do is get permission from each of those people to make sure that you can do what you want to do with the recording. Okay, we've had a question in about disabled students and recording lectures, and again from Elaine, thank you very much. And this is the question about whether a disabled student in a lecture can just record the lecture, and how does this pan out against the rights of the lecturer?
Well, I was looking at an example from the University of Leeds Equality Unit recently. And they give the advice out in advance that students in effect have the right to record lectures just as they have to make a record of any part of the lecture, you know, handwritten notes, whatever. In effect, they have the prior right to take an audio recording for their own use, and that is given without having to ask the lecturer's permission. And that is an example of their position, and one would assume that other universities would adopt a similar position. However, if a student chose to rebroadcast the audio through other media, then there may be another issue. But certainly a disabled student who wants an audio recording shouldn't have any problem at all.
From the legal point of view, this is a very interesting question, because it's one of those areas where the law doesn't provide the neat answer that we would like. Whenever I copy my CDs onto my mobile phone, even though I bought the CDs, I'm committing a technical infringement of copyright. Likewise, when even a student with a disability makes a recording of a lecture for their own purposes, they are technically infringing the copyright unless they have permission of the lecturer and the institution. There's nothing that changed that. The Equality Act doesn't change that. That doesn't permit otherwise illegal activity. However, the Equality Act does place a duty on the institution to ensure that the conditions are there for the student to be able to fulfil their learning. And to that extent, that places a duty, arguably, on institutions to make sure that the staff give that permission, and the institution gives that permission.
Does the Single Equality Duty Act give in effect another reason for an institution to make their policy clear again?
Absolutely. In fact, they're required by the Disability Equality Duty and the Single Equality Duty to make the changes that will allow have a positive impact on allowing all students to study.
So this might give an opportunity for the disability support officer in an institution to make the new position clear, as
Absolutely.
The laws recently changed.
Yep. It may involve things like changing the contract of employment for new staff to make it clear that they will be required to give the rights to the institution to allow students to fulfil this, to make the situation absolutely clear. Again, we're not saying it's a situation whereby disabled students should be stopped from recording lectures, unless there are very particular circumstances where recording of lectures is absolutely inappropriate.
While we're mentioning the Single Equality Duty Act, Techdis have made a handy guide which can be obtained from techdis.ac.uk, a short guide to the Single Equality Duty in an education context.
Excellent. Thank you very much. Go into some technical issues then. From Kenny, he says, one major problem is the lack of light for the camera in the typical lecture theatre. I think you alluded to. Lecturer wants it totally dark, no doubt, for the slide presentation, but the camera won't see anything. Is there any compromise that can be reached there, or are we stuck with two different purposes that we're trying to fulfill?
Well, no, I think there are ways around it. I mean, if you want to see an expensive way around it, you take a look at a TED Talk on the video. You've got a situation there where you're looking at slides and you're seeing a wonderfully lit presenter, but that's being done with a professional crew using professional lighting. Taking a step back to something a little more feasible for an institution. I know there are a couple of lecture theatres at the University of Nottingham that I'm familiar with, where they've actually installed a little spotlight in the ceiling of the lecture theatre, which just points down on the podium, and it's fine. It's just a single light. It's not, you know, professional quality, but you can get a nice view of the lecture, and it doesn't interfere with the slides whatsoever. So something as simple as that, and it doesn't have to be permanently installed. You could theoretically get a light that you can set up and install to shine on the podium when you're doing a lecture that you're going to video.
That's it. And another one, you spoke about the availability of lecture capture systems and automated systems. How should an institution go about deciding between the ones on offer?
Oh dear. You could try them all. Alternatively, I think what I would do is actually ask around people at different institutions that use different systems. There are a number of systems, you know, Panopto, Camtasia, Echo 360, a number of other ones, which all, you know, do the job to varying degrees. I don't think you can give a flat answer saying, you know, this is better than those. They're all intended for the same purpose, and they all have different, you know, ways of accomplishing it.
I suppose with all of these things, and again, I'm sure many in IT and procurement will be aware of the difficulties in identifying actually what you actually want beforehand, and then matching that up to the specification.
But this is where we have an opportunity for academics using these different resources to share their experiences. Using something like the subject network through the Higher Education Academy, you may find instances of stories where people have used and tried out these systems and reported their advantages and disadvantages. So searching the case studies through the Academy may give you some insight into how the best system was selected.
Thank you very much. Okay, back to two legal questions then, which we'll take together, and that's about the question of what happens if lecturers are presenting content that is not copyright free or is sensitive in nature. This happens quite a lot at the moment. You invite along a guest lecturer, you may tell them in advance that please clear any third-party material, though when they actually turn up they're going to show a PowerPoint presentation or video that includes an awful lot of other people's material that's not been cleared, either because they just didn't get around to thinking about it, or because they are copyright anarchic and believe that they should be able to go ahead with what's there. This can put you in a difficult situation, because what is clear is if you incorporate and distribute material which is not cleared copyright-wise, you run a risk. And that's you will be liable because you are distributing it, as well as them being liable as well. Now that's a pity, because that may have a freezing effect on what you can do with the video. So perhaps then, winding the clock back, it's worthwhile making clear to whoever you're inviting to give the lecture what you intend to do with it in the future, and then why it's important that you can, with some certainty, give it out. There's also sometimes a risk decision to be taken. And there are some people who drive at 31 miles an hour in 30 mile an hour zones. I've mentioned about copying CDs and ripping the tracks to my mobile phone. I do that in the knowledge that that's infringement. And I take the view that that's within my permissible bounds of things I can do, and I'm not robbing anyone. So I do take that decision. And again, there's something about risk and fairness that's involved in this decision. We do take decisions with regards to risk. The decision to show 30 minutes of, for example, a major Hollywood film as part of a guest lecture and record that and put it up would be ill-advised. Very hard to see that. If it's truly a review or criticism of a work, and you're doing that criticism review fairly, then we do have the benefit of, in black and white, in an act of Parliament, an exception that allows that, and it should be used. But it has to go that far, use what is necessary and not for more than that. And it can be further disseminated. Channel 4 famously in a case used this provision for showing parts of a film as part of a critique. So that's possible.
Well, while we're still in the discussion on preparation stages, I forgot to mention, really, there's an opportunity for the lecturer to consider what accessibility gains can be made, and think of those as a separate process. Don't just think of the specifics of the audience, the cohort that they're teaching that year, but in general, what accessibility gains could be made by making this a video lecture. The hearing impaired, visually impaired, dyslexic students, all sorts of opportunities arise, and if a lecturer takes a little time aside to see what those gains might be, they may be an important outcome in the performance for that particular group of students, which can then be demonstrated as a subsequent gain.
Absolutely, I've certainly benefited from subtle changes sometimes that have been made which allow me to gain access to so much more content via my mobile phone. And we've had a question about how mobile technologies comes together with this. We're going to leave that for now because we're eating into or we're drinking into coffee time indeed, and so we don't want to take up much more of that. We will be back later on with more questions, and thank you very much for all those. In around just over 5 minutes time, at 3:05, we'll come back and look at actually on the day itself, what sort of things can you do to make your life easy when making the recording.